What should we do before the Grim Reaper comes? The easy answer is clear your debts, atone for your sins, and prepare a will. You probably need a consultant and a counselor for the first two. As for the will, let us tell you why you should have a will and what happens if you don't. To encourage us to make more videos like this, please like, share, and subscribe. We will really appreciate it. Thank you. A will is a legal document that sets out the distribution of your assets according to your wishes, using the 4W and 1H approach. It helps your family members to identify what assets you have, where they are kept, who the assets are given to, how you want them to be distributed, and when you want it to be given. It helps your heir to have a faster and easier access to your assets. Apart from that, if you have kids who are still minors, a will can help identify who should care for them. Most importantly, it can help prevent that estranged auntie of yours from having a hand in your assets. The cost for preparing a will is low. With a will, a grant of probate will be obtained from the High Court through the assistance of a lawyer. When there is no will left behind, the process of administrating the assets is more laborious and time-consuming. This is called intestacy. The first thing your family will need to do is to agree on the appointment of an administrator who will take the lead to administer the estate. If you have a child who has not reached 18 years old, a minimum of 2 administrators are needed. The second thing to do is for the family to consult a lawyer to explain the intricacies of the Distribution Act 1966 and the Probate and Administration Act 1959. In summary, your assets will be distributed to your spouse, parents, and children in accordance to this table. For example, if the deceased leaves behind a spouse, parents, and children, the spouse will obtain 1/4 of his assets, the parents will obtain another 1/4 of his assets, and the children will obtain half of his assets. Another example is if the deceased leaves only a spouse and parents and there's no children, both the spouse and parents will then have half of his assets. If there's no spouse, parents, or children left behind, then your estate will be distributed to your siblings, grandparents, uncles and aunties, yes, including that estranged one, great-grandparents, great-granduncles and great-grandaunties, and the government. Notwithstanding these distribution arrangements, your beneficiaries can agree among themselves on an alternative arrangement if desirable. Once agreed, the necessary consents and renunciation of rights will need to be signed by the beneficiaries. Lastly, your family can either choose to proceed to administer your estate either through the High Court or the Land Administrator's Office. If your estate consists of at least one landed property and other assets not exceeding 2 million ringgit in value, it will then be classified as a small estate under the Small Estate Distribution Act 1955. Your family can then petition to the land administrator for a letter of administration. Alternatively, a similar letter of administration can also be obtained from the High Court. Both the grant of probate and the letter of administration appoints an individual to collect the assets and distribute it to the beneficiaries. The main difference is that the individual in the grant of probate is appointed by you in your will, and the distribution of assets will be as per your will. Whereas in the letter of administration, the individual will be your next of kin, and the distribution of assets will be in accordance to the law. Usually, it will be less costly to obtain a grant of probate. The benefit of having a will really outweighs not having one. We recommend that you get one before your number's up. As the saying goes, nothing is certain in life but death and taxes. So, what are you waiting for?